Hello, I'm Jack Hanna, the Director of the American Bar Association Criminal Justice Section. Today at the Museum in Washington, D.C., we are pleased to share information on the pressing implications of the recent Supreme Court decision, Padilla versus Kentucky. Every player in the system, whether prosecutor, defense lawyer, or judge, may need to become familiar with the collateral consequences of a criminal record. This video resource will contain a number of components that you may find useful. The video segments can be utilized individually or collectively as a progressive training tool. The separable portions of the video provide specific instructions to prosecutors, defenders, and to judges on how to comply or comport with Padilla. This guide to attorney compliance with Padilla includes a thoughtful discussion of the Supreme Court opinion with leading scholars and practitioners from around the country. Another video portion contains a description of our criminal justice section project to track the collateral consequences of a criminal conviction in all 50 states. We thank the Open Society Institute for its generous support. Additional supplemental written materials to this video are available online on the ABA Criminal Justice Section Padilla resource page.
Welcome to the American Bar Association Criminal Justice Section presentation on effective assistance of counsel under Padilla. I'm Gwendolyn Washington, a staff attorney at the D.C. Public Defender Service.
I'm McGregor Smythe, Managing Attorney for the Bronx Defender Civil Action Practice and Director of ReentryNet.
And I'm Benita Jen, Co-Director of the Immigrant Defense Project, a Defending Immigrants Partnership founding member.
We are pleased to share practical information that will assist defense attorneys in complying with the Padilla versus Kentucky decision. This portion of the video will cover an overview of immigration consequences of criminal dispositions, Padilla versus Kentucky's holding and main points, what defense attorneys must do to meet the requirements under Padilla, key concepts in immigration, including the main categories of offenses that render a non-citizen removable, other related issues that may come up, a list of online and written resources, hotlines, and experts available for consultation, and finally, how Padilla may more broadly affect collateral consequences and defense strategy. First, let's start with an overview of immigration consequences of criminal convictions. More than a loss of liberty is at stake for a non-citizen defendant facing criminal charges. There are several possible adverse immigration consequences that can flow from a criminal case disposition. Those consequences include, but are not limited to, deportation, which is sometimes mandatory, detention during a deportation case, also sometimes mandatory, loss of ability to obtain permanent residency, asylum, or other lawful immigration status, loss of lawful permanent residency, temporary or permanent ineligibility for naturalization, and ineligibility for waivers or relief from deportation. Sometimes a conviction is necessary to trigger immigration consequences. Sometimes an admission or something less than a conviction is enough to trigger an immigration consequence. So, what type of offenses are we talking about here? What should raise a red flag when you're representing a non-citizen? The short answer is that almost any disposition can have an immigration consequence for a non-citizen. It is a highly individualized inquiry based on your client's particular set of facts. Defense counsel should be aware that each and every stage of the criminal case can lead to immigration detention and deportation. Defense counsel has an affirmative duty to advise the non-citizen client of the specific adverse consequences that may result from his or her criminal case. Benita, can you elaborate for us what the Supreme Court said on Padilla versus Kentucky?
Sure. So Padilla v. Kentucky is one of the most important Supreme Court decisions regarding defense counsel's responsibilities under the Sixth Amendment. In Padilla, the Supreme Court recognized something that immigrant and criminal defense communities have known for decades. And that is that immigration law is incredibly harsh for those who have had any interaction with the criminal justice system, and that deportation penalties can be the most important part of the penalty for a conviction, and in fact can be more important for many people than going to jail. For example, a conviction for first-time shoplifting or possession of a marijuana joint can result in permanent exile and family separation for an immigrant who's been in the U.S. since she was a child. And that's something that I think very few of us would consider an equitable or proportionate penalty. And as a result, the court has recognized that accurate and affirmative legal advice for immigrants facing criminal charges is absolutely necessary for a fair and constitutional criminal justice system. In this section, we will discuss exactly what the Supreme Court said and what this means for defense counsel. First, a few words about Mr. Padilla. Mr. Padilla was a lawful permanent resident commercial truck driver who had served in the U.S. military during Vietnam. He was charged with marijuana possession and trafficking for having marijuana in his truck. He pled guilty to trafficking after his defense attorney told him that he didn't have to worry about deportation because he had been in the U.S. for such a long time. And as Mr. Padilla knows now, this advice was incorrect. His conviction, in fact, made him deportable and ineligible for relief or any kind of a pardon from deportation. The Kentucky Supreme Court, in his case, decided that deportation is a collateral consequence and outside the scope of the Sixth Amendment. The Supreme Court of the U.S. disagreed and held 7-2 that the Sixth Amendment requires defense counsel to provide affirmative, competent advice to a defendant regarding the immigration consequences of his guilty plea. Non-advice or silence on this issue is insufficient. I'd like to note two additional important points of this decision. One, the court found that professional standards provide the guiding principles for what constitutes effective assistance of counsel. Thus, we should look to established professional norms to identify the steps that defense attorneys should take when representing a non-citizen. And the court cited as examples the ABA pleas of guilty standards and the NLADA guidelines for defense lawyers. As the court stated, authorities of every stripe, including the American Bar Association, criminal defense and public defender organizations, authoritative treatises, and state and city bar publications universally require defense attorneys to advise as to the risk of deportation consequences for non-citizens. The second point is this. The court endorsed the idea of informed consideration of immigration consequences by both the defense and the prosecution during plea negotiations in order to come up with an agreement that's acceptable to defense and that promotes justice, for example, by mitigating the immigration consequences. So defense attorneys can now point to this language in Padilla when they're discussing plea options with their prosecutors. And prosecutors should no longer be dismissing out of pocket your plea proposals simply because they're partially designed to mitigate immigration consequences, or worse yet, trying to structure pleas to make deportation more likely. And finally, as you'll hear from McGregor, the court's reasoning that deportation is an integral and sometimes the most important part of the penalty, and that immigration consequences are inextricably linked to the criminal case may well apply to other penalties. The bottom line of Padilla, however, is this. If you are a defense attorney, you must determine whether your client is a citizen of the United States. And if he or she is not a citizen, you must advise him or her about immigration consequences of the criminal charges and possible pleas. It's not enough to say, I know that some convictions lead to deportation, but I'm not sure about your case. It's not enough to say, you should consult an immigration lawyer. And it's also not enough to simply tell all of your clients that they may be deported. Immigration law, as Gwen was saying, is highly dependent on individual facts, and you must provide affirmative and individualized advice about immigration consequences to every non-citizen client. And if there are two words you should remember from Padilla, it's these two words, affirmative and individualized.
Many defense attorneys have been properly advising their immigrant clients for years, and some public defender services even have immigration experts on staff to assist PDs with this task. For some others, this is something new. Think of it like this. It's like other areas of law, like DNA testing and forensics, something that requires us to gain new skills if we don't already have them. and requires our practice to grow, change, and adapt. We are confident that expertise and defender resources will expand to meet this need, but until then, we want to offer a few quick tips on how to meet your duties under Padilla. Benita?
First, what must a defense attorney do in order to meet her duty under Padilla? We have identified 4 steps. A defense attorney must investigate her client's individual facts, ascertain her client's wishes, analyze the immigration impact of key defense decisions and accordingly advise her client, and finally, defend the case according to the client's priorities. These steps are essential to providing your client with competent advice regarding how the immigration case will affect his or her immigration status. The steps aren't that different from what you may do in any other criminal case, but there are some unique considerations for immigrants within each step. And we'll discuss each of these steps in turn. The first step is to investigate the facts. Again, immigration consequences depend on a number of facts, and you can't conduct this analysis without them. Some critical information to get from your clients right away is immigration status, criminal history, immigration history, and family ties. Gwen, you're a public defender. Do you have any advice or tips for defenders on how to do this first step?
Yes, Benita, I do. When you're investigating your client's immigration status, keep in mind that some people may be reluctant to discuss their status with you. Your clients won't always understand why you want this information or trust that you won't report them to the federal government for deportation. Explain why you want to know. Also, remember that not all clients are aware of their immigration status. Investigation may mean speaking with your client's family members or guardian. And when you're investigating the client's criminal history, and you want all information, even low-level violations and misdemeanors, diversion programs, and deferred adjudications. If your client has priors, get the penal statute and the exact subsection under which your client was convicted. You want to know about sentences, all sentences, including probation terms and any restitution amounts if there are any. Equally important, you want to investigate your client's immigration history. This includes the date that your client entered the United States, any prior orders of deportation. The 1-800 number you see on the screen may help ascertain if your client has had an outstanding order of deportation or is in proceedings. Please note that a proposed policy may make it harder to get this information in the future. For family ties, which are sometimes crucial in determining if your client has any relief available from deportation, you want to know about the spouse's immigration status, children and parents, including their ages against the immigration status and whether or not they have citizenship. Benita?
The second step is to ascertain the client's wishes. Does the client want to prioritize a good immigration result or a lesser penalty or something else? Gwen, do you have any tips on that?
Yes, it's important to find out what's important to the client. Is the client willing to serve more time in jail or in custody to prevent possible immigration consequences that may arise from a sentence? In some cases, more time in custody could mean saving the client adverse immigration consequences. In other cases, more time will make the immigration consequence worse. Or in yet more other situations, the sentence may not matter at all. Benita?
The third step is to analyze the immigration impact of key defense decisions and advise the client accordingly. What do you think?
You do this by researching the adverse immigration consequences that may affect your client from arrest through judgment, sentencing, and other post-conviction events, such as a parole or probation. This means reading the applicable immigration statutes, consulting reference guides and case law, and consulting with experts if necessary.
And you should do the analysis that Gwen just discussed and provide this advice to every non-citizen client. Remember, many of your clients, especially those who have legal status or citizen family members, will have no idea that a plea could lead to deportation until you tell them. And the fourth step, of course, is to defend the case according to the client's priorities. Gwen, do you have any tips here?
If protecting current or future immigration status is a priority for the client, then a defense lawyer should look for a plea offer that will not subject a lawful permanent resident client to deportation